This is case number 22CR000182, State of Ohio versus Dartavia S. Bex. Mr. Bex is in court, represented by counsel. Attorney Tim Kuharski, representing the State of Ohio, is Assistant Prosecuting Attorney Jenny Azuri. The court referred Mr. Bex to the Adult Probation Department and Dr. Rinsberg for a competency evaluation. The defendant did not initially appear. I revoked bond. Dr. Rinsberg did examine him. He generated a report dated October 14th, 2022, opining to a reasonable degree of certainty that Mr. Bex was in fact competent. I have met in chambers with both attorneys, and it's my understanding that both will stipulate to the report.
That is correct, Your Honor.
That's correct, Your Honor.
And Mr. Bex, you know everything that's going on here?
Yes.
All right. You want to get back to work?
Excuse me?
You want to get back to work?
Please. Yes.
All right. Court finds the defendant competent. Any reason that I shouldn't reinstate bond?
No, Your Honor, from the defendant's perspective.
No, Your Honor.
Bond's reinstated. Anything else?
No.
Nothing at this time, Your Honor. Thank you.
All right. We're adjourned.
Thank you, Judge. Yeah, absolutely. Thank you.
All right.
I mean, it doesn't matter. No, don't worry about it. Hello, how can I help you?
Is that for jury? Yeah, go right in the office, here.
Right to those, everyone was. rise. This Court of Common Pleas is now in session. The Honorable Eugene A. Lucci presiding.
Be seated. This is case number 22CR000666. Hewitt, Mr. Hewitt, Public Defender Billy Kilmeyer, representing the state of Ohio as Assistant Prosecuting Attorney Amy Alessi. The defendant was last here on August 29th, 2022. He waived indictment, pled guilty to as charged, count 1, improperly handling firearms in a motor vehicle, felony 5, and a forfeiture specification for the 2 pistols, magazines, ammunition, and count 2, OVI, a second in 10 years, misdemeanor 1. I referred him for a pre-sentence investigation and report and set sentencing for today. I reset his bond at own recognizance with conditions that he have a scram unit applied, no driving, and no alcohol or drugs. I have received a pre-sentence report prepared by the Lake County Adult Probation Department dated October 6th, 2022. I've received a drug and alcohol evaluation provided by Dr. Rinsberg dated October 25th. 2022. I've read these documents. I will make them part of the record. Any inaccuracies or any modifications needed to the PSR documents? Mr. Kilmeyer?
None at this time, thank you.
And do you agree that the jail time credit is 1 day?
Yes.
All right. Any reason not to proceed?
No reason not to proceed.
Go ahead.
Thank you. Your Honor, at this time, the defense is going to request that the court sentence Mr. Hewitt to a term of community control through the Lake County Adult Probation Department. We believe Mr. Hewitt is an ideal candidate for community control, as he does have consistent employment. He has been a pipe fitter at Construction Mechanical in Cleveland for quite some time now. He's held that job. It's been a reliable source, not only a way to fill his time, but a reliable source of income. He is a high school graduate and has 2 kids, one of whom lives with him, and that would be his 3-year-old. The mother of those children has custody of one of them as well, and Mr. Hewitt pays child support in order to be an active participant in that child's life as well as support them financially, which again is why his job at Construction Mechanical Inc. is all the more important. I believe he is a very low risk of reoffending in his 29 years of life to this point. The 2 charges he has here in front of you are 2 out of his 3 in his criminal history, the other being his predicate OVI in 2019. Your Honor, I would also ask, in addition to the imposition of community control as a sentence in this case, that Mr. Hewitt not have to engage in any jail time at the Lake County Jail beyond what the minimums for a second OVI call for. Beyond that time that would be required by the mandatory minimums for a second OVI. As he does have a job and has a child at home that relies on him for the care and stability in life if he were to have to go to the Lake County Jail for any extended period of time, he would, in all likelihood, lose his current position at construction mechanical, which would not only be a great disruption in his own life, but a great disruption in the life of his 3-year-old who lives with him, as well as the child that relies on his financial support through the money that he pays every month. So again, Your Honor, I would ask at this time that Mr. Hewitt receive a sentence of community control with no jail time that extends beyond the mandatory minimum set by law for a second OVI. If the court does find a jail sentence prudent in this case, I would ask that Mr. Hewitt be allowed to report on November 7th. That would be next Monday, so that he does have the week to line up care for his child, as well as see if he can make any arrangements to keep his job during his stay. Thank you.
Andrew Hewitt, the law allows you to say whatever you want me to consider before I sentence you. What do you want me to know? You do have to move the microphone closer to your client.
It's just because it's
And you can stay seated.
I just want to say I'm sorry. I am not a criminal. Listen, I guess. Sorry.
All right. Let me hear from the state.
Thank you, Your Honor. As part of the plea agreement in this case, the state agreed to recommend community control sanctions. And initially, the state might have been open or receptive to recommending to this court an outpatient IOP or drug and alcohol assessment. However, while the defendant has been on bond to this court, he has violated on 3 separate occasions. First, the time of his referral, he tested positive for marijuana. He was on scram. His court directly ordered him not to consume drugs or alcohol as a condition of bond. And he consumed alcohol on 2 occasions, on October 20th and on October 23rd. And as a result, this court revoked the defendant's bond. It is clear alcohol contributed to this offense, and the defendant has not abided by this court's orders or followed the orders of this court to not consume alcohol or drugs. Therefore, the state is asking for a jail treatment program, a mandatory fine, the license suspension, 6 points assessed to his driver's license, and to forfeit the firearms listed in the forfeiture specification. Thank you.
I said that it wasn't reading. You have to reset it. It was not to return. You have to reset it.
Was there something you wanted to say to me?
Your Honor, today was the first, I had been aware of the scram violations. In speaking with Mr. Hewitt, he was indicating that he was not drinking on those occasions. I can't speak to the accuracy of the readings, whether or not they were valid. I know they often are. I'm in no way questioning the legitimacy of scram as a whole. But in speaking with Mr. Hewitt, he was indicating he's not drinking on those occasions.
Okay, so the report shows that there was a first consumption on October 20th, 2022 at 5:05 p.m. The defendant reached a peak of .181 at 7:38 p.m., then returned to 0 You see the motion?
I believe there is a typo. That should be October 21st, not
The
October
21st.
Yes, Your Honor, I apologize.
So then returned to 0 the next day by 7:55 a.m. The total length of the alcohol event was 14 hours and 50 minutes. Then there was a second confirmed consumption, October 23rd at 12:06 a.m. the defendant reached a peak of .293 at 3:41 a.m., returned to zero by 4:59 p.m., 16 hours and 53 minutes later. Did you drink the alcohol?
No, sir, I was not drinking.
I can't hear you. You gotta speak up. I cannot
Sir,
hear you.
Sorry, no, sir, I was not drinking.
You said you were not drinking.
No.
Okay. Then, I need to have more information because if he wasn't drinking, then that will drive my decision one way. If he was drinking and denies it, that will drive my sentence in a different direction. So I'm not going to sentence you, and I want to hold a hearing with someone with expertise on the scram and on these events. All right, anything further?
No, Your Honor, thank you.
I would just ask that Mr. Hewitt's bond be continued after its play.
Well, I already revoked it on Friday because of the positives. So the bond remains revoked. All right, we'll get it on the schedule as soon as we can. We're adjourned.
So, let's make a
All right.
Can you step your job out?
All rise. This Court of Common Pleas is now in session. The Honorable Eugene A. Lucci presiding.
May be seated. We're on the record. This is case number 22 CR 000883, State of Ohio versus Cody J. Allen. Mr. Allen is in court, represented by counsel, Assistant Public Defender Mary Springer. Representing the State of Ohio is Assistant Prosecuting Attorney Barbara Zagreski. The defendant is charged in a one-count information filed by the Lake County Prosecuting Attorney on September 8th, 2022. The charge is possession of a fentanyl-related compound, a felony of the 5th degree, a Division B offense, and a forfeiture specification for the contraband and instrumentalities. The defendant filed a motion for intervention in lieu of conviction. I referred the matter to the Lake County Adult Probation Department and Dr. Rinsberg for an analysis. He was assessed by an appropriately licensed professional. The court determines he is eligible for intervention. The court has reason to believe that substance abuse was a factor leading to his criminal behavior. Intervention would not demean the offense. However, the court cannot find that intervention would likely reduce future criminal activity. Because this is the 28th criminal and delinquency case spanning a number of years, and that the defendant has been afforded opportunities and breaks over the years and has multiple contempts and probation violations. And the court exercises its discretion to deny the request for intervention. I'm informed by your attorney that whether intervention was granted or denied, you still wish to proceed. Is that correct with the plea?
Yes, Your Honor.
So the charge, possession of a fentanyl-related compound, is a felony of the 5th degree, carries a maximum penalty of 12 months in prison, maximum fine of $2,500, a maximum driver's license suspension of 5 years. Do you understand the major potential penalties?
Yes, Your Honor.
You understand you have the right to have the Lake County Grand Jury consider the evidence as presented by the prosecuting attorney and for the grand jury to determine the charge or charges. In doing so, they could land on the same charge we have here. They could charge you with something more, something less, or nothing at all. The point is, it's totally up to the grand jury. Do you understand that?
Yes, Your Honor.
Have you discussed this decision about waiving indictment and pleading guilty to a prosecutor's information?
Yes, Your Honor.
And has your attorney answered all of your questions to your satisfaction about that topic?
Yes, Your Honor.
Do you give up the right of indictment?
Yes, Your Honor.
I'm going to hand you a document called Waiver of Indictment. Make sure you've read it. Make sure you understand what it says. Make sure you agree with what it says. And if you sign it only because that's what you want to do.
Thank you, Your Honor. Mr. Allen has the waiver of indictment in front of him, and we have gone over it together. He has executed his signature on that document today here in open court that I have just witnessed and signed myself.
Yes. I will make the waiver of indictment part of the record. So before I can accept your plea of guilty, I have to determine if you know and understand the rights you are giving up, the consequences of a guilty plea, and that you are entering this plea of guilty of your own free will. How old are you?
29, sir.
And how far did you go in school?
I completed 12th grade, but I didn't graduate.
Okay. And do you have the ability to read, write, and understand the English language?
Yes, Your Honor.
Do you hold any kind of state-issued occupational license or certification?
No, Your Honor.
Are you currently under the influence of any drugs, alcohol, or medication of any kind?
No, Your Honor.
And you can just say yes or no is fine. Have you taken any within the last 48 hours?
Yes.
And what do you take?
It's anxiety medication provided by the jail. I forget what it's called, honestly, but.
All right. And when did you last have it?
Yesterday at 6 p.m., 7 p.m.
All right. And to help you sleep?
Yes.
Okay. Does it interfere with your ability to think clearly?
No.
Are you thinking clearly now?
Yes.
No trouble understanding me so far?
No trouble.
No trouble understanding what you and your attorney talked about before we started the hearing?
No.
And have you been treated for mental illness before you went to the jail?
No.
No. So have you received a copy of the information, the charge?
Yes.
Did you read the charge?
Yes, sir.
Do you understand the charge?
Yes.
Did you discuss that charge with your attorney?
Yes.
Did she answer all of your questions to your satisfaction about the charge?
Yes.
Do you agree that that charge describes what you did?
Yes.
And do you wish to plead guilty to that charge and the forfeiture specification attached to it for contraband?
Yes.
I've been handed a 4-page document called Written Plea of Guilty. You probably went over this document with your attorney before we started the hearing, is that correct?
Yes.
And did you read this document?
Yes.
Do you understand it?
Yes.
Did you discuss this document with your attorney?
Yes.
Did she answer all of your questions to your satisfaction about the document?
Yes.
Do you agree with what it says?
Yes.
And do you wish to sign it?
Yes.
I'm going to go over the charge you are proposing to plead guilty to so that we are all on the same page. Count 1, the one and only count, reads that on August 11th, 2022, in the city of Mentor, Lake County, Ohio, you knowingly obtained, possessed, or used a fentanyl-related compound, a Schedule I controlled substance. That's called possession of a fentanyl-related compound. It's a felony of the 5th degree. It's in violation of Revised Code Section 2925.11, and Division B controls when it comes to determining whether I should impose prison. Do you understand that charge?
Yes.
And is that the charge you wish to plead guilty to here today?
Yes.
Attached to that charge is a forfeiture specification that says that at the time of the offense you had in your possession fentanyl, which is contraband and/or an instrumentality of the offense you committed, and you would forfeit the item. Do you understand that?
Yes.
And do you wish to plead guilty to that?
Yes, sir.
You understand if you plead guilty to the charge, you are admitting you committed the crime.
Yes.
You understand that if you had any defense to the charge, you give up that defense by pleading guilty.
Yes.
You understand by pleading guilty, you are giving the court the power to sentence you immediately.
Yes.
You understand that by pleading guilty, you cannot appeal any rulings previously made by the court, including my denial of your request for intervention in lieu of conviction.
I understand.
You have certain trial rights. You're giving them all up by pleading guilty. I'm going to explain them to you one at a time. I need to make sure that you know and understand you have these rights and that you're voluntarily giving up these rights. As I explain your rights to you, if you have any question about what I'm saying, or if you need a better explanation, you need to speak up and let me know. Otherwise, I will assume you understood and answered the question that I asked you. Fair enough?
Fair enough.
You do not have to plead guilty. You have a right to have a trial to determine whether you're guilty of any crime. A trial would automatically be by a jury in this court unless you decided you wanted a non-jury trial. A non-jury trial is a trial where you want the judge not only to make all of the decisions throughout the case, but you want the judge to make the ultimate factual determination in the case whether the state can prove your guilt beyond a reasonable doubt. Do you understand that?
Yes.
Do you understand that a trial gives you the ability to test every aspect of the state's case, both factual and legal? You understand that with a jury trial, the jury makes the decision, I don't, whether the state has proved its case against you. Furthermore, it takes all 12 jurors to agree that you're guilty before it's even possible for you to be convicted. Do you understand that?
Yes, sir.
The state of Ohio is required to prove your guilt beyond a reasonable doubt. If the state failed to prove even one essential element of the particular charge beyond a reasonable doubt, you could not be convicted of that particular crime. Your plea of guilty provides the court the entire factual and legal basis upon which to convict you and sentence you, and by your plea, you are relieving the state of any obligation to prove anything, let alone prove it beyond a reasonable doubt. Do you understand that?
Yes.
You have the right to confront your accusers, meaning to have your attorney question all of the state's witnesses under oath in front of the judge and jury. Do you understand that?
Yes.
You have the right to use the subpoena power of the court to compel witnesses you need to come here to testify for you, especially witnesses who are reluctant to come to court, out of state, or incarcerated someplace. I can get them here for you. Do you understand that?
Yes.
You have the right to tell your side of what occurred here and testify in your own defense, or you could refuse to testify. It's one way or the other, but it is your choice. No one can compel you to testify if you did not want to, and if you chose not to testify, that could not be used against you to prove that you were guilty. In fact, the prosecutor could not even comment on your silence to infer you might be guilty, have something to hide, maybe have a prior conviction. The jurors would be told you have that constitutional right not to take the stand and testify. We would select only individuals to serve as jurors in your case who answer under oath during jury selection that they will uphold that right. Do you understand all of that?
Yes.
Do you understand that if you were not pleading guilty today, you would always be represented by an attorney at law throughout this case, free of charge to you, paid for by the taxpayers?
Yes.
Do you understand that if you were not pleading guilty today, you could appeal any of the decisions I would make throughout the case? You could appeal the jury's verdict. You would have a free transcript typed up of everything that was said or done in this court, so you can demonstrate to a higher court any mistakes made here to get those mistakes corrected, and a free attorney to handle that appeal for you. Do you understand all of that?
Yes.
You understand a plea of guilty is a complete admission of guilt.
Yes.
Do you voluntarily give up all the rights that I just explained to you and wish to have this court accept your plea of guilty to count 1, possession of a fentanyl-related compound, felony 5, and the forfeiture specification attached to it?
Yes, sir.
Are you now, or were you, at the time of this offense in August of 2022, on parole, post-release control, community control, or probation to any court anywhere?
Yes.
And tell me about that.
I was on community control in Cuyahoga County.
And on which case?
On
3 cases?
no, just one.
1 case.
One case, sir.
But you were on bond on 3 cases when you committed
For
this.
Menor, Willoughby, and the felony that got bonded over through Menor.
Okay. And you've never been to prison, correct?
No, sir.
And you have no felony convictions on your record?
No, sir.
So you understand, by pleading guilty, you are voluntarily giving up your liberty for whatever length of time I sentence you to prison, jail, or community control.
Yes, sir.
And you understand on this charge, I can send you to prison for 12 months. If I did send you to prison, 6 months would be the minimum, and it would be a whole number of months between 6 and 12, and I can fine you up to $2,500.
Yes, Your Honor.
You understand you would forfeit the contraband and instrumentality?
Yes.
You understand that I can suspend your driver's license for a period of up to 5 years?
Yes.
You understand that while in prison, you may be eligible for, be offered, and be able to earn some credit against prison time to be served by engaging in programming offered to you for that purpose. The prison credit maximum is normally 8% of time to be served, but because you don't have your GED or high school diploma, you might be able to stretch that to 10% or a certain number of days, according to the regulations. Do you understand that?
Yes.
Upon your release from prison, you could be on post-release control, PRC, in the discretion of the Ohio Adult Parole Authority for a period of up to 2 years. They'll give you rules. You violate their rules, they can return you to prison for up to 6 months, even for 1 violation. All of that time is part of the sentence. And should the violation be a new felony, the judge in a new felony case, in addition to sending you to prison on a new case, can send you back to prison on this case for another year, and all of that time is already part of the sentence. Do you understand that?
Yes.
If I chose not to send you to prison, I would place you on community control sanctions that could last for up to 5 years.
Understood.
As part of the community control sentence, you'd have to abide by all probationary conditions established for you in the case by the court, which would include time in local jail, fine, abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance, any treatment I determine you need, substance abuse or mental health, community service, license suspension, the forfeiture, a no-contact order, anything I determine you need to do. Do you understand? You would be required to perform exactly what I tell you to do, exactly how I tell you to do it.
Yes, sir.
If you fail to do so, you'd be brought back before me on a probation violation. I will conduct a hearing. If I determine that you did violate your community control sanctions, I can extend the period of time that you're on community control for up to that 5-year maximum. I can increase the nature and severity of the other conditions under the community control, meaning more time in jail, more treatment, more things to do. Or I can terminate community control altogether and just send you to prison for 12 months. Do you understand that?
I understand, sir.
You understand a conviction for this crime renders you disqualified from purchasing, owning, possessing, or using firearms or ammunition for firearms.
Yes.
And do you possess or own any firearms?
No, sir.
You understand that there are, and that firearms disabilities, both state and federal, you understand that?
Yes.
And you understand that there are other disqualifications that accompany a conviction of this sort. If you were to end up in prison, you cannot vote from prison. You'd have to re-register to vote upon your release from prison. While on community control or on post-release control, you cannot serve as a juror in the case where the state of Ohio is a party, because you would still have an active case with the state on the other side, and you cannot hold any position of public honor or trust. Do you understand that?
I understand.
In addition to the fine and the forfeiture that I mentioned, do you understand I will order you to reimburse the government the cost of confinement, community supervision, any treatment, and court costs?
Yes, sir.
You understand the cost of confinement also includes transportation costs between the court, the jail, and the prison institution.
Yes.
You understand I will enter a judgment against you for the costs of prosecution.
Yes.
If you fail to pay that judgment or timely make payments on a payment plan approved by the court, and you are serving a community control sentence rather than a prison term, you may be able to substitute community service to work it off. By local rule, you'd work it off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. Do you understand that?
Yes, sir.
You understand a failure to pay all fines or costs in full can result in the state blocking your motor vehicle license plates until they are paid.
Yes, sir.
Do you understand all of the potential penalties?
Yes.
Do you have any question at all as to what can happen to you as a result of your plea of guilty today?
No, Your Honor.
You understand no promises have been made by the court, the prosecutor, your attorney, or anyone as to what I will do when it comes time for sentencing.
Yes.
And you understand when it comes time for sentencing, I am not bound by and do not have to follow the recommendation of the prosecutor, your attorney, or even a joint recommendation as to the sentence.
Yes.
And has anyone made any kind of promises or threats to you in order to get you to plead guilty?
No.
Are you entering this plea freely and voluntarily?
Yes.
Have you told your attorney everything you considered important in this case?
Yes.
Have you had enough time to discuss what you're doing in this case with your attorney?
Yes.
Although this may be your attorney's recommendation for you to plead guilty as charged, is this your own decision and voluntary act to do so?
Yes.
Has your attorney done everything you've asked her to do for you in this case?
Yes.
And are you completely satisfied with the legal representation provided by Mary Springer, your attorney?
Yes.
Ms. Ogreski, what would the facts show if the case went to trial?
Facts would show that on August 11th, 2022 in Menor, Lake County, Ohio. Officers were arresting the defendant on an outstanding warrant. They conducted a search incident to arrest and found in his pants pocket a rubber smoking pipe used to smoke marijuana and a bundle of what at that time they suspected to be heroin. When asked about it, the defendant, Cody Allen, stated that it was heroin. It was sent to the Lake County Crime Lab and turned out to be a combination of parafluorofentanyl, Schedule 1 controlled substance, and fentanyl, a Schedule 2 controlled substance, in the amount of less than 0.06 grams.
And Mr. Allen, did you hear and understand everything the prosecutor just said?
Yes.
And is everything she said true?
Yes, sir.
What is your plea to one count of possession of a fentanyl-related compound, felony 5, a Division B offense?
Guilty, sir.
Your plea to the forfeiture specification?
Guilty.
I'm going to hand you the written plea of guilty, that 4-page document we talked about earlier. Make sure you've read it, make sure you understand what it says, make sure you agree with what it says, and if you sign it only because that's what you want to do. I've made my markings on that document in red so you can easily tell what I've done to it since you last saw it.
Thank you, Your Honor. Mr. Allen has before him the written plea of guilty. We have gone over it in its entirety. I've answered all of his questions related to it, and I have just witnessed his signature here in open court on the document, and I have signed it as well.
Your Honor, may I pitch?
Yes.
Any of the court that has written to your guilty, golf, so that when guilty the truth is not
The court will sign the judgment entry at the end of the document and make the written plea of guilty part of the record in the case. Record should reflect that defendant Cody J. Allen was here with attorney Mary Springer in open court. I informed Mr. Allen of all of his constitutional rights. He's made a knowing, intelligent, and voluntary waiver of those rights. I find he understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. Finding it to be knowing, intelligent, and voluntary, I accept his plea and find him guilty as charged. Count 1, possession of a fentanyl-related compound, a felony of the 5th degree, a Division B offense in violation of Revised Code Section 2925.11, and the forfeiture specification attached to it for contraband and instrumentalities. Tony, did you do start a PSR? Oh, wait a minute, never mind. The court already has a PSR as the defendant was referred for intervention workup. Any reason not to proceed to sentencing at this time?
No, Your Honor.
Go ahead.
Thank you. After having a chance to review the pre-sentence report and drug and alcohol assessment, Mr. Allen would ask the court to impose a term of community control sanctions at this time. This is his first felony conviction. It is a low-level drug-related offense. It's a small amount of drugs. Unfortunately, Mr. Allen is a victim of the opiate epidemic. In 2018, he hurt his back. He was prescribed Percocet by his doctor, and then his substance use addiction spiraled out of control from there. Mr. Allen has been with me, and I think other, law enforcement, probation. He's been very upfront and honest about he needs help, he needs treatment, and he's done that since the very first time that I've met him. He is willing to comply with any of the court's orders, should the court give him an opportunity of community control. And he is excited to continue on a path of being abstinent from substances and sobriety. He was able to maintain a period of sobriety of about 11 months, but unfortunately had a relapse in 2021. And he's really just trying to take care of all of the things that he has going on in the legal arena. And he's asking the court to give him that opportunity. Thank you, Your Honor.
Cody Allen, the law allows you to say whatever it is you want me to consider before I sentence you. What do you want me to know?
I feel like whatever you give me is an opportunity, and I should take it and take every advantage I can and learn everything I can from it and just move on from this and just live my life in a better way.
All right, let me hear from the state.
The state recommends community control as well.
I've considered the record, the oral statements made, pre-sentence report, drug and alcohol, evaluation, as part of the intervention workup, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution along with the public burden. I've considered the joint recommendation of the parties for a community control sanction. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in the statute. In that regard, there are no factors making the offense more or less serious. In terms of recidivism, there are factors that make recidivism likely. The offense was committed while on community control on one case and while on bond on 3 other cases. Defendant has a previous criminal history and history of juvenile delinquency. This is his 10th substance abuse conviction, his 28th criminal or delinquency case. He's had multiple contempts and probation violations on previous cases. He did overdose twice, not as an intentional suicide attempt. The defendant is not employed. He has a moderately high Ohio risk assessment score at 33. He was given a break in 2019 in the Cuyahoga County Court of Common Pleas, whereby an F5 was dropped to an M1, and he still had multiple probation violations on that case. There has been a rehabilitation failure after previous convictions and a failure to respond in the past to probation. There is a pattern of substance abuse, and the offender refuses to acknowledge a problem or accept treatment or apply treatment tools previously given to him, and he's had a couple attempts at treatment. In terms of making recidivism less likely, the defendant is genuinely remorseful and has a positive attitude. Under 2929.13b1, there is no presumption in favor of community control because the offense was committed while under community control and while out on bond on multiple cases. The court determines that the defendant is amenable to an available community control sanction, that community control is appropriate here. The court will adopt the joint recommendation for community control. The court hereby imposes a period of community control for 3 years, subject to the general supervision and control of the Lake County Adult Probation Department under such terms and conditions that it finds appropriate. Among these, you shall not leave the state of Ohio without the permission of the court, and you shall abide by all laws, including but not limited to the laws related to firearms, deadly weapons, and dangerous ordnance. The court further imposes the following specific sanctions and conditions. A period of incarceration in the Lake County Jail for 142 days, with credit for 82 days already served, the last 30 days of which you shall enter, participate in, and successfully complete the jail treatment program and follow all aftercare recommendations. Immediately following your stay in the Lake County Jail, you're to be transported to the Northeast Ohio Community Alternative Program, NeoCap, in the city of Warren in Trumbull County. Enter, participate in, and successfully complete that program and follow all aftercare recommendations. While there, you're to be supervised by the Trumbull County Adult Probation Department. Immediately following your stay at NeoCap, you're to be transported back to Lake County for an additional 60 days of transitional day reporting, which can be reduced or eliminated based upon stabilizing factors in your life, predominantly residential and substance abuse and mental health. You are to continue your mental health treatment and follow all recommendations, including any aftercare, abstinence from alcohol and drugs of abuse, periodic screens to monitor your compliance, a minimum of 5 12-step program meetings per week, have a sponsor, and be involved in a home group. You're to obtain your GED. You're 29 years old, so you're not too old to do it. You were very close to graduating, and I think that will give you a little bit of an edge on employment. You're to have full-time employment or school or combination of employment and school, but outside of any establishments that sell or purvey alcohol or drugs as the primary source of revenue. Because your preferred drug is an opioid, I want you to consider medication-assisted treatment, Vivitrol, and if you enter the program, follow all recommendations, including aftercare. One doctor, one dentist, one pharmacy at any one time prescribing or filling prescriptions for you. You're to inform the Adult Probation Department of any change of provider, sign medical releases so that they can monitor drug-seeking activity on your part, and inform your providers of your addiction. You're to take all medicines as prescribed, forfeit all contraband and instrumentalities. You're to pay the costs of prosecution, confinement, community supervision, treatment, and court costs. A violation of this order will result in a prison term of 12 months. If you do end up in prison, post-release control is optional for up to 2 years. They can return you administratively for up to 6 months, even for one violation. Should the violation be a new felony, the judge in a new felony case, in addition to sending you to prison on a new case, can send you back to prison on this case for another year. All of that time is already part of the sentence. While in prison, you may be eligible for, be offered, and be able to earn some credit, capped at 8%, possibly 10% of time to be served, or a certain number of days according to the regulations, by engaging in programming offered to you for that purpose. So long as you're not in prison, you may be able to substitute community service to pay off the costs of prosecution, working off at the rate of $10 per hour. Each hour of work performed reduces the judgment by that amount. So long as you owe any court costs, the state can block your motor vehicle license plates until they are paid in full. Bond, if any, is released. Is there anything further from the state?
No, Your Honor, thank you.
Defense?
No, Your Honor, thank you.
Probation? All right, good luck. For on record, this is case number 17 CR 000504, State of Ohio versus Jeremy J. Lewis. Mr. Lewis is in court, represented by counsel, Assistant Public Defender John Fatika. On behalf of the Lake County Adult Probation Department is Probation Officer Dave Tompkins. The defendant was here on June 8th of 2017. He waived indictment, pled guilty as charged. One count of receiving stolen property, felony 4. I referred him for a pre-sentence investigation and report. Set the case for sentencing, reset his bond. I sentenced the defendant on August 10th of 2017, adopting a joint recommendation for community control to 2 years of community control with 125 days in jail, credit for 113. Used to do the Think for Change program, abstinence, screens, a curfew, obtain his GED, have full employment, pay restitution, take all medicines as prescribed, perform community service, take a program of anger management counseling. He used to handle probation violation in Cuyahoga County and other requirements. I told him a violation would result in a prison term of 18 months. I notified him of the potential and consequences for violation of post-release control. I explained earned credit, substituting community service for costs, and the state block on the motor vehicle registration. The defendant returned to the court on November 25th of 2019 on a probation violation. He pled guilty to a probation violation whereby he was arrested by East Cleveland PD on July 13th of 2019. I determined that was a technical violation. I held sentencing. I extended his community control by 1 year to a total of 3 years with 94 days in jail, credit for 94 on the violation. The overall credit as of that date was 219 days. All of the conditions remained as ordered on August 10th of 2017. Told him again that a violation would result in a prison term of 18 months. I notified him of the post-release control. The defendants returned to the court on another set of probation violations. I've met with counsel and probation in chambers, and the parties agreed to amend the probation violation to allege a second count. The first count is a violation of Rule 8, which requires sobriety. The probation officer at the time, Jillian Gibson, in an affidavit dated June 18th of 2020, alleged that the defendant submitted a urine screen on June 11, 2020 that tested positive for marijuana. The state of Ohio would have filed a motion to terminate community control. The amendment is, and that the defendant has failed to report ever since June 11th of 2020. And you say he did have another charge of identity fraud somewhere else, correct?
That's correct, Your Honor, in Cuyahoga County.
All right. And how far along is that case? Where is it in the procedural?
The arraignment is scheduled for November 15th.
All right. So, would you consent to the amendment of the technical violation of being arrested again.
Yes, Your Honor.
So there are 3 charges here as amended by agreement. First one is positive marijuana. The second one is failing to report since June 11th of 2020. And the third one is an arrest for identity fraud. What was the date of that?
October 20th of this year, Your Honor.
Okay, just a few days ago.
I'm sorry. The initial arrest, it says, was December 8th of 2020.
December 8th of 2020.
That's correct. I have the, would you like the hard copy of the docket?
I won't need it. And Mr. Lewis, do you understand the 3 charges? The
Yes.
positive marijuana, failing to report ever since June 11th of 2020, and being arrested for identity fraud on December 8th of 2020.
Yes.
And you understand you're entitled to a probable cause hearing, the purpose of which is for the court to determine whether there's a reason to continue to hold you to answer for the violations. You're entitled to a final hearing whereby the court would require evidence to its satisfaction that you violated in 1, 2, or all 3 ways alleged. And if I so find, you're entitled to a sentencing hearing. Do you understand these hearing rights?
Yes.
And you understand your exposure here is 18 months in prison for the felony 4.
Yes.
And have you discussed with your attorney the waiver of your probable cause hearing, the waiver of your final hearing, a plea of guilty to the 3 violations, and any other option you may have at this point?
Yes.
And has he answered all of your questions to your satisfaction
Yes.
about all of that?
Yes.
And have you been to prison before?
No.
So do you give up the right to a probable cause hearing?
Yes.
Do you give up the right to a final hearing?
Yes.
And what is your plea to the first violation, positive marijuana?
Guilty.
The second violation, failing to report since June of 2020.
Guilty.
And the third violation, being arrested for identity fraud on December 8th of 20.
Guilty.
Court finds that the defendant has knowingly, voluntarily, and intelligently waived his rights to a probable cause and to a final hearing, has entered a plea of guilty to the 3 violations. Court finds the defendant guilty of all 3 violations and determines that the first 2, the marijuana and the failing to report, are non-technical because they are either a crime or evidence of an abandonment of the purposes for community control. The arrest for identity fraud is a technical violation because the defendant is presumed innocent on that, but the violation is being arrested. Any reason not to proceed to sentencing at this time?
No, Your Honor.
Go ahead.
Mr. Lewis, as the court just heard, accepts responsibility for his misconduct. During the time he's been away, he's worked at factory jobs for Triad Staffing. He's been homeless for part of the time. He's had some family issues. He's 28 years old. As of today, he's got 231 days of jail credit. We'd ask the court consider all those factors and impose a sentence that's toward the low or mid-range of the sentencing spectrum. Thank you.
Jeremy Lewis, the law allows you to say whatever it is you want me to consider before I sentence you. What do you want me to know?
I was trying to get my life together.
Well, the first thing you got to do is go by the rules, right?
Correct.
Was any restitution paid, Dave?
I don't believe so, Your Honor.
Mr. Lewis, you didn't pay any of the restitution, correct?
To the
It was $692.
to her, yes.
Pardon?
To her, yes.
Judge, there's no record of anything.
You said yes?
To the victim, yes.
Yes. He says he paid restitution to the victim. All of it?
There's no record of any payments.
Did you say you said you paid all the restitution?
I probably gave her like probably 4 or something.
Judge, even in the notes, there's no indication of any payments made
Not
throughout the years.
not to the PO, but I'm talking about
To the victim personally?
right.
Okay, if you explain that to the judge.
To the victim personally.
I can't hear you.
To the victim personally.
To the victim what?
I've been giving her money.
You gave the victim money personally? Did the victim give you a receipt? Okay, so who did you give the money to? What's the victim's name?
Jarquil.
What?
Zarquil.
Sarcoello?
No, Zarquil.
Zarquil, Your Honor.
Okay, pretend I'm deaf. I can't hear you. I cannot hear you. What's the name of the victim?
Zarquil.
Yeah, try and speak up.
Oh, Zarquil.
Zarquel. Zarquell? Is that how you spell it?
Right.
I show the victim is Santa M. Lou Jolly. Who is Zarquel?
That's our granddaughter.
Is Santa M. Lou Jolly dead?
No.
Why would you pay the granddaughter? So, do you have any proof other than me sending someone out to talk to Zarquel to find out how much you paid and when you paid it? And how do I find out whether Zarquel gave it to Santa M. Lou Jolly? How do I find out if the victim got what you, and you said you paid her, you said 4 something, $4 and something cents or 400 and some dollars?
400.
Okay, don't abbreviate that. I have a record here, and I cannot, first off, I can't hear what you're saying. Secondly, when you're saying an abbreviation, I don't even know what that is. So is this person going to say, if I send a probation officer out, that she gave the money to the actual victim, her grandmother?
I'm not sure.
Why aren't you sure is she going to lie to the probation officer? If you gave her 400 and something, what is she going to say? Shouldn't she say you gave her 400 and something and that she gave it to her grandmother?
I don't know.
You don't know. What did you give Zarquel money? Is that her first name or her last name?
First name.
That's a first name. What's the last name?
Brady.
Brady?
Mm-hmm. Like Tom Brady.
Okay. So what did you give her the money for?
For the car, for the restitution.
Dave, do you know anything about this?
Judge, I don't. This case was started from back to the department. I'm looking through the case notes, and there's no indication of any payments being made anywhere. Restitution, court costs, revision fees, nothing.
All right. So I'm going to order it, and if the victim says that Zarquel Brady gave her 400 and something dollars towards restitution, then fine. But if the victim says, no, I didn't get anything, I don't know what he gave her money for, I didn't get it, then you're still going to have to pay the victim the money. You understand? You didn't steal it from the granddaughter. How old is the granddaughter, by the way?
21.
21? And when did you give this money to her? All at one time?
No.
Over a period of time? Why didn't you just pay it through the probation department? I mean, I ordered it. You do everything else. You're supposed to do everything else through the probation department. Why didn't you pay it through the probation department to make sure you got credit for it?
Because I thought that she...
Well, here's the thing. If you gave her money to give to her grandmother for restitution that I ordered on this case and she didn't, then she stole the money and she should be charged. Right?
Correct.
All right, so you'll be testifying at her trial. Correct?
Correct.
Okay, so I'm going to mark in my notes that you are willing to testify against her at her trial if she didn't give the money to her grandmother as you instructed her to and for that purpose, correct?
Correct.
Okay. I've considered the record, oral statements made, victim impact, pre-sentence report, my conference in chambers with defense counsel and probation officer, and the statements of the defendant and the defendant's counsel. I've also considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, which are to protect the public from future crime by this offender and others similarly minded, and to punish this offender and promote the effective rehabilitation of the offender using the minimum sanctions that the court determines accomplish those purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution, along with the public burden on governmental resources. I've considered the recommendations of the parties. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victim, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in Divisions B through E of Revised Code Section 2929.12. In that regard, there's no change in the seriousness factors from the original findings. However, in terms of recidivism, there has been a change such that recidivism is much more likely. In addition to findings that were made previously, there's been a rehabilitation failure, a failure to respond to community control. The defendant has absconded for almost a year and a half, has used illegal drugs, has been arrested again. Dave, did the defendant complete the Thinking for a Change program?
Yes, he did.
Did the Thinking for a Change program help you think?
Yes.
When did you complete that program?
I know it was in the winter time.
In the winter time? Last winter, 2 winters ago, 3 winters ago?
Maybe 2.
When did he complete?
January 18th.
Of 18. So apparently it didn't work too well. Did you obtain your GED?
No.
Did you perform any community service that I ordered?
Yes.
How many hours, Dave?
Judge, he did the full 25.
Okay. Anger management counseling?
That was completed.
All right. Did he handle the probation violation in Cuyahoga County?
Yes.
And of course, the big one, the defendant absconded for a year and a half. The court finds no factors making recidivism unlikely. Under 2929.13b1, there is a presumption for community control. The presumption no longer exists because of the multiple violations. Court determines that the defendant is not amenable to an available community control sanction. Prison is needed to protect the public. A minimum sentence would demean the seriousness of this offender's conduct. Accordingly, your community control sanction is terminated. I'm imposing a prison term of 11 months on count 1, the felony 4, with credit for 231 days. I'm repeating the restitution order, $692 to victim Santa M. Lou Jolly, judgment for that amount, monitored by the Ohio Adult Parole Authority, tabled through the clerk of courts. And if Ms. Lou Jolly acknowledges that she received part of the restitution, then you would only owe the balance. You would pay the costs of confinement, prosecution, supervision, treatment, and court costs. Upon your release from prison, you could be on post-release control in the discretion of the Ohio Adult Parole Authority for a period of up to 2 years. To give you rules, you violate their rules, they can return you to prison for up to 9 months for any one violation, actually up to 5.5 months, and for any one violation. If the violation is a new felony, in addition to going to prison on the new case, you can go back to prison on this case for the greater of 1 year, or whatever length of time remains unexpired on that potential 2 years of PRC. All of that time is part of the sentence. And you did not get your GED as I ordered yet, right? Okay.
I can't.
While in prison, you may be eligible for, be offered, and be able to earn some credit, capped usually at 8% of time to be served, may be stretched to 10% by engaging in programming offered for that purpose, including obtaining your GED. I don't know if you're going to be down there long enough to even get into programming. As long as you owe any court costs, the state can block your motor vehicle license plates until the costs are paid in full. Is there anything further, Mr. Fatika?
No, thank you, Your Honor.
Dave, anything further? All right, good luck. We're adjourned.
3.5 months to do, okay? And then you have a case waiting for you in Cuyahoga County. When if Cuyahoga County doesn't pick you up from here, you should let them know that you're at LCI. Be brought back as soon as you can, okay?
Kyle will pick me up from here.
You know if he has a holder? I wouldn't know. Go ahead and stand up. Better facing. They always run them.